whoever might be the government after the next election has to make a decision either to do something or to stop saying that it's going to intend to do something, because this matter has been on the agenda for many, many years. Should we have a Charities Commission or not? What structure should we have in place? We've had an Industry Commission 1995. Yeah. We've had extensive consultation with the sector leading to the Charities Definition Bill. And it's a goldmine for the lawyers, because they like to entice you into using them to make submissions. We then had the Productivity Commission most recently. We had the Henry Tax Review. All of the major charitable organisations in this country, the major churches, have made submissions to all of those. Now, it's not my place to give direction to government, but it would be good to either say, here is a model that we can consult about, that we can actually get into the detail of and see whether it's workable or not, yeah, and how we fine-tune it, or leave the status quo, but not continue this process of creating uncertainty. If I could just perhaps make one further comment. When this inquiry was announced, I had the bursar of one of the Catholic schools ring me in terror, because regrettably the bursar had been misinformed that this bill, Senator Xenophon's draft bill, would mean that the school would now lose its charitable status. Now, 10 minutes on the phone reassured him and all was well.
And that was a letter from the Church of Scientology?
It may have been. I don't know where that came from.
Or an offshoot?
I don't know where that came from. But fortunately, before he went to the lawyer to get some advice about this, we were able to resolve his problem. It's the uncertainty in the sector, Senators, that I'd suggest ought to be taken into account, particularly when we are proposing significant change, such as the presumption to the public benefit test, without knowing what the criteria will be, what will be the background, what will be required, because that does create a cost.
Senator Xenophon,
I'm
we're going to go for an extra 10 minutes on this because we...
I'm sorry if I've spoken too much.
I've only got one line of questioning. I think Senator Cameron's covered a number of the concerns quite adequately, very adequately rather. You've said, Father Lucas, that the UK test is problematic. You referred to an Orthodox Jewish retirement home in your evidence. So there was a problem in relation to an aged person's facility in the UK.
Yes.
That's right. And that happened, that's the Pennyland House in
Jewish.
Cardiff.
Yes.
Yes, you're familiar with the case?
Yes.
And you've read the decision of the Charities Commission in relation to that?
Yes.
Well, the Charities Commission didn't actually knock out the Pennyland House Jewish Retirement Nursing Home. They said it was a charity, but it wasn't operating for the public benefit because the trustees hadn't adequately demonstrated the charity is currently operating for the public benefit because their policy on assistance with fees wasn't clear, open and transparent. They didn't have a funding strategy to ensure that its benefits are more widely accessible, and they actually said, come back to us in 3 months' time to put a plan in place to meet the requirement and submit the plan within a further 9 months.
Yes.
Well, that's not terribly draconian or anything, is it?
It's not the question of whether the test is draconian, it's the questions that they're asking. And this was the point of why I say the test was problematic. They said, in the absence of a clear budgeted plan of targeted assistance to help in cases where top-up fees cannot be afforded.
What's unreasonable about that?
Because that's not what public benefit means. The public benefit is not about whether or not a particular group of people have access to the institution. The public benefit test in the common law is, in fact, because it's a disqualifying test, if this Jewish home only looked after the people that the people who ran the home were connected with, it would fail the public benefit test. Public benefit is the opposite of private benefit. It's not a question of whether or not there is open access or fee support. That's the point I'm making. Yes, this organisation can tick the box by going through the motions of having some fee subsidy, The point that I'm saying, Senator, about it being problematic is that with due respect to the guidelines of the UK Charities Commission, they have moved away from the common law test. If you look at the
Sorry, can we just go back a step though in
Yes.
relation to that, Father Lucas? You've got a report in the media said that senior Jewish welfare figures do not believe that the Commission's finding in Cardiff would affect their institutions. You have the Chief Executive of Jewish Care, Simon Morris, who said, our understandings of the Charity Commission are concerned to ensure that where charities charge for services, they communicate clearly to people that they can use their services even if they can't afford to pay for them, and how they can do this. And Leon Smith, the Chief Executive of the South London Home Nightingale, commented, we've looked at the report very carefully and we're not concerned. We don't see this as a major problem for the sector. Nobody would be precluded from coming to our home because of finance. We make it clear in our literature.
Yep.
I don't see why you're so concerned about this decision.
What I'm saying is that the test they've applied, with due respect, is not the right test. They can be not unhappy and they can tick the boxes. What I'm suggesting, if we are going to design a good public benefit test, is that we need to distinguish the common law public benefit test as it's explained in tax ruling 2005-21, which is about excluding organisations that are privately controlled where the benefit is private. The public benefit test was never about open access or access to a wide number of people. That was never the common law test.
The decision's not saying that though.
Well, with due respect, that's precisely one of the criteria that they require. Because they said, in the absence of a clear budgeted plan of targeted assistance to help in cases where top-up fees cannot be afforded. In other words, they have to have a system whereby they allow people who otherwise can't afford the fee structure to have access. That is not what public benefit was ever meant to mean.
Well, can I just, on that
Sorry,
point,
can I just, but this organisation had quite significant net assets, but it was just a question of saying, tell us what your processes are, be open and transparent about it. What's wrong with that?
That is, well, whether it's right or wrong, that is not what the public benefit test in the common law meant.
No, I'm talking about leaving aside the issue of the common law public benefit test. Do you consider that unreasonable or onerous to require a level of transparency about how you charge for fees and what level of assistance you can provide for people that can't afford your fees?
It is problematic if, for whatever reason, you don't provide a level of assistance.
Not necessarily. It's a question of being open about it, given the constraints of your organisation.
But there is an expectation that they will provide that assistance. And I'm saying that is not what public benefit means.
Perhaps we'll agree to disagree about the interpretation of the decision. Sorry, Senator Cameron.
yeah, I'm just having a look at the Treasury submission, and I think very concisely outlines the common law definition of charity. It goes to the Statute of Elizabeth,
Yes.
and then moves to Special Purpose Commissioner versus PEMSO,
Yes.
and then outlines the four heads for charity. The relief of poverty, so the merchant bank retirement home wouldn't come under that. The advancement of education, the merchant bank retirement home wouldn't come under that. The advancement of religion, depends whether they're all Catholic merchant bankers, I'm not sure, but probably wouldn't come under that. And other purposes beneficial to the community, not falling under any of the preceding heads. How is it beneficial to the community for people of substantial means to be given tax-free status for a retirement home? I just can't understand this, to be honest. And then you go on to the other areas, not acting unlawfully, not predominantly engaged in political advocacy, not providing private benefits, and be operating in the public benefit. So it seems to me, if you do PEMSO, you have to come back to public benefit. And I'm struggling to understand why a retirement home for merchant bankers would qualify under the public benefit when it's costing the public money to do this.
Well, firstly, Senator, we have to establish whether or not this particular retirement village is costing the public money, and we've got to determine how that retirement village is structured. I mean, if it is simply a series of self-care, independent living units, that's one particular structure. But if these merchant bankers are suffering dementia and require some measure of sophisticated medical care, with due respect, rich people with dementia are as much in need as poor people with dementia.
Sure.